Good day, Crime Talk aficionados. We have another great show for you today. First, who is showing up at the Bryan Kohberger trial? And the judge in his trial says autism is not enough to spare his life if he's ultimately convicted. Prosecutors dispute the allegations in the Luigi Mangione motions. The Karen Reed trial, we have an update. A woman is sentenced for killing her boyfriend because she thought he was cheating on her. This day in legal history and our dumb criminal of the day. Let's talk about it.
Lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and yes, you can check us out anytime on any of your favorite podcasting apps. Now, before we get to the show, remind you, go to crimetalksearch.com, sign up for that background subscription service today. When you do, you'll be able to do as many background search as you desire, and you literally get a report prepared while you wait. That report is going to have information as to what the person's phone numbers are, what emails are associated with them. You're going to find out if they have a criminal history. Are they married? Are they divorced? Are they on one of those sex offender registries? That's right. Everything you want to know about a particular individual, either coming into your life or whether you're trying to make the decision of whether to get them out of your life, go to crimetalksearch.com. You're going to be happy that you did. All right, let's go ahead and open the record today for Tuesday, April 29th. All right. April 29th, 2025. First on the docket, Bryan Kohberger. All right. We brought you a show last Friday. It was a very detailed analysis and reading of all of the lengthy orders in the Bryan Kohberger matter. So trying to summarize a couple of the orders that the court gave last week, so you don't have to listen to the entire thing. But if you did, we'll put a link below for you to do so. But the question is going to be, who's actually showing up? Now, remember, the witness list, like just about a lot of things in the Bryan Kohberger case, have been sealed. So we're able to tell through the court's rulings who a lot of these witnesses are. Now, the prosecution has endorsed hundreds of potential witnesses. And remember, they're not going to call all those witnesses. But if anybody literally touched a file from the police department, if some police agency did something, they are listed as a potential witness. If somebody was interviewed and they said nothing was observed, guess what? They still have to go on a potential witness list. So we know generally there's hundreds of witnesses out there. However, what it boils down to is very few will be called, but what we know from these orders that these people will be called. So first, who do we have? We know that Jenny Ayers, the forensic scientist from the Idaho State Police, she's going to testify. She's a hybrid fact expert witness, and she's going to testify about crime scene processing, including DNA, bloodstains, fingerprints, hair, fibers, and shoe impressions. And she will explain the DNA presence and collection, her work processing of the defendant's apartment and an office, and any rebuttal testimony regarding the crime scene at 1122 King Road. Now, the defense had said that her disclosures lacked specific opinions on crime scene processing of DNA, and the court said, guess what? Her testimony is factual, not opinion-based, and her work adequately disclosed, and she is qualified. So the challenges about specificity are for cross-examination, not exclusion of that witness. We also know that Special Agent Nicholas Balance, he's the FBI cell phone analyst. He'll testify about analyzing the AT&T cell phone records for the defendant and the victims. He's going to testify about drive testing to map various phone locations from June to November of 2022 and how cell phone towers and call detail records work. His 30-page report outlines his methodology and findings. Now, the defense claimed that the report omits key data, for example, like handoff data, drive test mapping, and various methodology per the defense expert, this Cy Ray guy. Basically, the court's ruling was that the disclosures completely comply with Rule 16 requirements, providing opinions, facts, and data, and omissions or methodology disputes are for cross-examination. You don't get to exclude the witness because you don't like their methodology in its entirety. But the testimony is limited to disclosed opinions, and if he exceeds those disclosed opinions, the court said the objections will be taken up at a timely basis, and they may be sustained. Then we have Heather and Jared Barnhart. They are the Celebrite digital specialists, and they're going to testify about how they analyzed Mr. Kohberger's cell phone and his PC, opining the data gaps, for example, event logs, Chrome history from November of 2022 are abnormal and may suggest anti-forensic methods. The defense challenge was that the disclosures imply habit evidence without clear opinions. The court said disclosures and the joint report meet the disclosure requirements, clearly outlining findings, not habit evidence, and no basis for exclusion. We know that a Michael Douglas from the FBI Forensic Accounting will testify. He will testify as a fact witness, potentially expert under 702, about financial transaction data of the defendant and the victims, noting changes like the defendant's shift to ATM withdrawals post-homicide. The defense challenged this potential witness, saying that there are no opinions disclosed with any particularity regarding the spending habits. The court ruled that Mr. Douglas's testimony is factual and not opinion-based and limited to observed changes. No basis for exclusion, though relevance concerns may arise at that particular time. Shane Cox, he's the Amazon litigation manager. Mr. Cox will testify as a facts witness, and he will testify about Amazon account documents, order, click, and sign-in history linked to the defendant from January to December of 2022. Now, the defense argued that there's no opinions are disclosed, and therefore he must be excluded. And the judge says no, he's a factual testimony witness, and any information that he's going to provide is probably above and beyond what is actually required. We also have a detective, Darren Gibson from the Idaho State Police. He's one of the lead investigators. Mr. Gilbertson will rebut defense expert Brett Turvey's claim of multiple assailants, testifying that time runs at the 1122 King Road show one person could have committed the homicides in roughly 2 to 4 minutes. Now, the defendants challenged this witness's testimony because they said that they questioned Gilbertson's expertise, relevance, missing data, for example, recordings of his test runs, and they're prejudiced due to his familiarity with the house. The court ruled that Mr. Gilbertson's investigative role qualifies him, and the experiment's simplicity negates disclosure issues. Now, relevance depends on defense testimony, and prejudice concerns regarding the house was vacated when he ran these tests. That's for cross-examination once again. Then we have the ISP, the Idaho State Police Forensic Lab scientists. There's multiple individuals. We have Catherine Dace, Taylor McKayek. They'll testify about evidence testing, referencing lab reports. The defense, once again, sought to limit testimony based upon lab reports citing vague initial disclosures. And the court said supplemental disclosures clarified the details and no prospective limit is needed. Once again, the defense can object to the testimony if it's beyond the disclosures at trial. We also know that Dr. Gary Dawson, he's a potential rebuttal expert for the prosecution. Dr. Dawson will rebut Turvey's multiple assailant allegation, opining that victim Madison Mogan's intoxication impaired her ability to resist, supporting a single assailant timeline. Now, the defense had argued that it's improper rebuttal since defense experts don't contest the toxicology results. But the court said Dawson's testimony is relevant if the defense expert's testimony implies a single assailant couldn't act quickly, and that relevance will be assessed at the time of trial. We also have detectives Mowry, Tanzola, and Uhrig. They are digital evidence witnesses that'll testify. Mowry from the Moscow Police Department, Tanzola from the FBI, and Uhrig from the Post Falls Police Department will testify about extracting and analyzing digital devices, finding no connection between the defendant and the victim's devices. And the defense sought to challenge this, basically saying that they want to limit the testimony to disclosed devices, citing a lack of specificity. But the court said there is a factual testimony about investigative process, and it is adequately disclosed with all data provided to the defense. No basis for a limitation. It goes directly to the police investigation. What did you do? Did you find it? Have these people have ever communicated? Or do they know each other? Or is this just some random killing? We also know the special agent Rob Hill. He is an FBI surveillance analyst, and he may testify to rebut the defense expert, Stephen Becker, who will say that surveillance footage shows that suspect vehicle 1 lacked a front license plate based upon a full video summary and specific clips. Now, the defense had sought to limit testimony regarding the video of the car to reference clips. Hill's opinion covering the full video summary, not just clips, so no limitation is warranted, the court noted. The court also addressed the defendant's motion to limit or exclude several expert witnesses disclosed by the state, alleging the deficient disclosures, and the state countered that all of the disclosure obligations have in fact been met. After that hearing on April 9th, the court came up with the conclusions that we just spoke about before. Now, the other big motion that we went in great detail with, but I'm going to give you the quick breakdown summary, was that the death penalty should not be applied to Bryan Kohberger if he's ultimately convicted and potentially sentenced to death. Obviously, the jury must unanimously decide if the death penalty is appropriate. But the defense made the argument that since Mr. Kohberger had recently been diagnosed as having autism spectrum disorder level 1, that it is a mental deficiency, and therefore somebody suffering from a mental deficiency should not be put to death. However, the court addressed whether autism spectrum disorder should be considered equivalent to an intellectual disability for the purpose of exempting Mr. Kohberger from the death penalty. Now, Kohberger had been diagnosed with this ASD level 1 just recently based upon his attorneys hiring psychologists and a psychiatrist to evaluate him. And they argued that his condition warranted a categorical exemption from capital punishment, citing constitutional protections that the United States Supreme Court had laid out in previous cases. However, the court in Idaho said no way. The court denied that motion, reinforcing that ASD is distinct from an intellectual disability and does not meet the criteria for such an exemption. This ruling highlights a critical misunderstanding about ASD. It is not a mental deficiency, but a neurodevelopmental condition with unique characteristics. So, the court noted the defendant, recently diagnosed with ASD by a clinical neuropsychologist, sought to strike the death penalty, arguing that ASD's social and behavioral impairments mirror those of intellectual disabilities, as outlined by Atkins v. Virginia, a United States Supreme Court case, which prohibits executing intellectually disabled individuals. Kohberger further argued that intense media scrutiny of his ASD-related behaviors, such as his deadpan look and rigid posture, could bias the jury, undermining his defense. The state argued that the ASD lacks the intellectual impairment central to the intellectual disability, and no national consensus supports exempting ASD individuals from the death penalty. The court, after reviewing the defense's own expert reports and legal precedent, agreed that the state's finding that there is no basis for a categorical exemption or a case-specific release due to media coverage. Bottom line, ASD, not a mental deficiency. Now, the court said, hey, ASD is a complex neurodevelopment disorder characterized by challenges in social communication and repetitive or restrictive behaviors as outlined in the DSM-5. Unlike an intellectual disability, however, it requires significant deficits in intellectual functioning, typically an IQ below 70, and adaptive skills. ASD does not inherently involve cognitive impairment, and the defendant in this case, for example, has an IQ of 119, placing him in the 90th percentile and demonstrating strong verbal abilities, with, not to mention, his academic success, including completing a master's degree with a 4.0 GPA. These traits underscore that ASD is not synonymous with a mental deficiency. Anyway, the court's analysis obviously emphasized the distinction, and, the ASD may share some adaptive challenges with intellectual disability, such as, social reciprocity or nonverbal communication. The absence of intellectual impairment disqualifies it from being treated as the equivalent under the Atkins Supreme Court case. The court noted also the wide variability in ASD symptoms, ranging from severe, which is level 3, requiring substantial support, to mild as level 1, as in the defendant's case. The spectrum nature makes it unsuitable for a blanket exemption, as the impact of culpability at trial Anyway, the defense argued that these evolving societal standards of ASD supports exempting affected individuals for the death penalty, pointing to increased diagnoses, the mental health initiatives like specialized courts. However, the court found no legislative or national consensus to support such a claim. Therefore, denied. Now, don't get me wrong. One would actually say, well, the guy is high functioning. He's working on his PhD. He understands what's going on here. As the court also noted in these reports that he understands and appreciates the proceedings against him. He understands the consequences, but he believes that he will be acquitted at trial. Mr. Kohberger does. But this is good lawyering. This is what lawyers for the defendant should be doing. So I understand how the court got to the opinion, and I think the order is correct. The United States Supreme Court says we're not going to, execute juveniles, and we're not going to execute people with an intellectual disability where they're very low functioning. So I think the court made the correct decision in this particular case. Ultimately, this can be mitigation that can be presented to the jury during the mitigation phase, assuming Mr. Kohberger is found guilty. And that may be enough because remember, the defense only needs one juror to vote for life, and then he will not get the death penalty. So hopefully that broke that down in the nice, succinct fashion. We hope it did. Anyway, you can watch the extended version at the link below. Next, Luigi Mangione. Pennsylvania prosecutors defend the arrest of the United Healthcare murderer suspect. That's right. The Pennsylvania prosecutors have declared that the arrest of Luigi Mangione, the man accused of the brazen murder of the United Healthcare CEO Bryan Thompson, that arrest and search was conducted lawfully and the evidence collected appropriately back in regards to his arrest in 2024. They're in Altoona, Pennsylvania. Now, Mangione, charged with first-degree murder, terrorism, stalking, and a host of other state and federal offenses, allegedly gunned down Thompson, the father of two, on a Manhattan sidewalk back in December of 2024. Ultimately, Mangione then fled to Pennsylvania, and obviously, it looked like when you watched the video of allegedly Mangione shooting Mr. Thompson, that it was a targeted attack, an execution, one could say. Anyway, Mangione's arrest following a 911 call from a McDonald's manager in Altoona reported seeing someone resembling the CEO shooter from New York. And according to the court documents filed yesterday, the Altoona police, acting on a valid, reasonable suspicion, approached Mr. Mangione in full uniform and followed protocols during the encounter. The prosecutors emphasized that Mangione willingly engaged with officers, providing forged identification without any attempt to leave or disengage the conversation. The pleading states, quote, "The Commonwealth avers that the police at all times acted within the authority bestowed by law," the filing stated, underscoring the legality of the detention and the evidence collected. The document further clarified that Mr. Mangione's interaction with law enforcement were voluntary and no coercion was involved by the police. Mangione's case obviously has had a lot of intense scrutiny, with charges spanning multiple jurisdictions and raising questions about motives of the broader implications of such a high-profile crime. Now, as everything unfolds, police remain steadfast in their assertion that the arrest was a critical step in bringing a dangerous suspect to justice, and the trial is expected to be obviously closely followed. The state court, we may be able to see that if courtrooms are allowed. The federal case, probably not so much. It's going to be an interesting case. I don't think the police are going to have been found to have violated anything based upon everything that I've read thus far. But, my opinion could change if something comes out at the motion to suppress hearing that will be held in the future. Next, the Karen Read update. Well, the Karen Read trial is back in court today for the 6th day of witness testimony. And a key witness, Jen McCabe, was currently on the stand as we were getting ready to do this. She was called after the cell phone expert finished the testimony about disputed Google search and John O'Keefe's movement the night of the death. McCabe's sister is married to Brian Albert, who at the time of O'Keefe's deaths owned the home at 34 Fairview Road in Canton, where O'Keefe's body was found. Now, McCabe began her testimony with questions about her background and how she came to meet Mr. O'Keefe. Mr. Brennan asked what her relationship was like with O'Keefe back in January 28th of 2022. She said, he was a very good friend of mine, and I knew I could call for anything from him. McCabe got to the Waterfall Bar and Grill in Canton around 9 p.m. on January 28th, eating and drinking with members of her family. She said the group was joined a short time later by Brian Albert and Brian Higgins, two men who Reed's attorney planned to say as part of their third-party culprit defense could be responsible for Mr. O'Keefe's deaths. Now, Higgins was an agent with the Bureau of Alcohol, Tobacco, and Firearms and Explosives, and it was revealed during the first trial that he exchanged flirty text messages with Miss Reed. Now, Reed and O'Keefe later joined the group at the Waterfall Bar. Just a typical average night, she described in her testimony, and that's kind of where it left off. As of then, you'll have to tune in tomorrow to see what happened. Anyway, the court ended the day Monday as defense attorney Bob Alessi was cross-examining Ian Whiffen, who works for Celebrite, a company that does forensic phone extractions. And Whiffen returned to the stand Tuesday with cross-examination complete after about 3 hours. Now, Brennan returned to redirect questioning today, and Whiffen testified about the timing of the key witness, McCabe's Google search about how long it would take somebody to die in the cold. He said that it happened after 6 a.m. on January 29th. Now, defense attorneys have said McCabe made the search at 2:27 a.m., hours before O'Keefe's body was even found. Now, according to Whiffen, the search registered at 2:27 a.m. because McCabe's opened an internet browser tab, then hours later used the same tab for the search she said was made at Reed's request. On cross-examination, Alessi said that during the first trial, one of the tools Celebrite used did show 2:27:40 a.m. as the time McCabe searched how long to die in cold, but it was later deleted. Alessi also said that a Celebrite competitor found the same and still has it in its record, while Celebrite removed the time stamp for that particular search. Anyway, Whiffen said it was removed in response to his research. It was changed due to the research I did, and it was verified by the forensic research team, Whiffen testified. He was asked by Mr. Brennan on redirect, did you go into your company's software and change it to accommodate law enforcement? Mr. Whiffen said, of course not. And then Mr. Brennan asked him, why would he not do that? His response was, aside from being unethical to change the data in that way, this is an artifact that is easily validated by an examiner. If I was to tamper with it for the purpose of changing the outcome of this case, it would be detected all of our customers immediately, and that would completely destroy the reputation of Celebrite, which I've got no intention of doing, Mr. Whiffen testified. Mr. Whiffen also testified that based upon his analysis on the night he died, O'Keefe died's phone never left the area of the flagpole in the front yard outside 34 Fairview Road in Canton after he arrived at Brian Albert's home. O'Keefe's body was found in the snow near the flagpole. The prosecution attempted to use Whiffen's testimony to show that O'Keefe's never went inside the home after getting out of Reed's SUV. The defense has argued that he was killed during a fight in the home and then dragged outside and left to die in the cold. Now, Alessi highlighted Tuesday that in Whiffen's report, he noted that when O'Keefe's phone arrived at 34 Fairview Road, the device turned into a westerly direction towards the home. Whiffen wrote in his report, it was difficult to say with any degree of certainty if the device actually moved. On Monday, Whiffen displayed a satellite image of 34 Fairview Road, which was owned by the time by Mr. Brian Albert. Now, the photograph included dots that give a general area where the phone was located throughout the night. And during cross-examination, Alessi highlighted that Whiffen did not include a second photo from his report that also has circles showing a wider range based upon the data where the phone may have been. Alessi said that when the circles are shown, a substantial amount of the house is included. Interesting and notable, you did not include the depiction in your timeline that you discussed with the jury yesterday, did you, sir? But it was important enough for you to put in your initial report, Alessi asked him. Whiffen was asked if, based upon the photograph, if the phone could have been in the house. He says, based upon the low accuracy information, yes. Later, during redirect questioning by Mr. Brennan regarding the accuracy of the location data, Brennan asked if a human lying on top of a phone could impact the accuracy of the data. Whiffen said he believes it could. Whiffin's report noted that the final health event recording on O'Keefe's phone came at 12:32 a.m. on January 29th of 2022, when he recorded 36 steps covering about 84 feet. Alessi showed Whiffin a report by the Massachusetts State Trooper Nicholas Garuno that shows the measurements from the flagpole to the front door, which is about 72 feet. Brennan later asked Whiffin on redirect if there's any way to know if these steps were taken in a straight line or if they could have been pacing or in a circle. Whiffin said there's no way to know. John O'Keefe's cell phone battery temperature was also an issue. Whiffin's direct testimony also attempted to show that the temperature of O'Keefe's cell phone battery also shows he never made it in the house. On cross-examination, Alessi tried to show that during Whiffin's experiment putting a phone in cold temperatures, the phone battery temperature dropped more quickly than O'Keefe's battery did the night that he died. Alessi said there was a much more dramatic drop in temperature in the experiments than there was in O'Keefe's phone battery data. Brennan asked on redirect if Whiffin covered the phone with anything when he put it in the freezer. Question was then asked if a human, was lying prone on a cell phone outside and had a body temperature directly touching the phone in your position, could that slow the process of the temperature decreasing as compared to simply just putting the phone in the freezer? Brennan asked, prompting an objection that was sustained, but the jury got it. Anyway, Alessi also noted that Whiffin did not know what the temperature was in Canton the night of O'Keefe's death, and Whiffin said he did not believe that it was important because he did not know the factors such as whether the phone was in a case or if the phone was in a pocket. I know it was a blizzard, but I don't know the exact temperature, he testified. The trial continues, ladies and gentlemen. You can see, the data, right? Are we really lawyers anymore? I think we're just data analysts. What does this show? What does this show? Where was it? Where's the GPS? Phones, I'm telling you, phones, they huge source of data. And like all things in life, there's lies, damn lies, and statistics. It all depends on who's interpreting the data. Next, a Lori Vallow juror speaks out. So it's been almost a week since a jury found Lori Vallow guilty of conspiring to kill her former husband, Charles Vallow. Obviously, the jury reached a unanimous verdict in about 3 hours of deliberation. Anyway, a juror by the name of Tass Reed Tucker gave an interview. The juror stated that they had never been through anything like this before. And obviously, this was the case for Lori Vallow, where she going through a separation, and her brother, Alex Cox, killed Lori Vallow's husband, Charles Vallow, and they claimed that it was self-defense. The police didn't file charges originally, and then once Lori Vallow was charged and convicted in Idaho, she was ultimately charged here as well. Anyway, the juror said that they wondered about where was the rest of Lori Vallow's family? Well, they didn't know. These jurors had no idea of the Lori Vallow case, so they had no idea that most of her family's dead because of her. Anyway, they thought it was kind of odd that there were no kids there. Where's her family? She just didn't have anyone. And it seemed like a kind of a question that was going on, but nobody wanted to really be able to ask or even answer. Anyway, when asked by the juror how Lori Vallow did represent herself, the juror said, I think in the beginning it was a little bit iffy, shaky, because she had to keep being corrected about how she was talking, the juror noted. But throughout it, I think basically overall, she did a pretty good job at representing herself. But the juror did note that one thing that really stuck out was her demeanor. She smirked at us, rolled her eyes, and shook her head. She just came off that she really didn't care about it, which goes to show you courtroom demeanor. I'm telling you, is so important, ladies and gentlemen. We also noticed in the Karen Reed case, she's not doing the eye rolling and the smirking and the overreaction because somebody told her to sit there and listen to the evidence. The juror also said that there's a lot of key evidence that stood out, like Vallow's other brother, Adam Cox, and Charles Vallow's sister, Kay Woodcock. I think she went in there hoping that they were going to crack or be on her side. And that was not the case. And they stood their ground pretty darn well, the juror noted, and said that she felt that the juror felt that Vallow tried to bring up some good points on cross-examination, like Vallow's questioning of the Chandler detective on why they didn't run certain tests on some evidence in this case, like the gun or the bat. The detective told the court We didn't think further testing was necessary. It stood out because we didn't know what he didn't test any of the evidence, and we thought that they possibly should have. Just goes to show you, ladies and gentlemen, the investigation, so key and important in any particular case, but clearly overwhelming evidence against Lori Vallow. The juror did know, it was kind of weird, did not present any evidence. I would remind that juror that the defendant never has to prove themselves innocent. They never have to call any witnesses or present any evidence in their case in chief if they choose to do so. A reminder there for everybody as well. Next, a 21-year-old sentence for killing her boyfriend. That's right. A 21-year-old woman in Missouri will spend decades behind bars for killing her boyfriend, fatally shooting the 24-year-old victim in the head on New Year's Eve after finding a message from him to another woman. Now, the judge ordered Madison Nicole Ruckert to serve 35 years in prison for the death of Jonathan Miller. Now, Ruckert had initially been arrested and charged with first-degree murder and armed criminal action over the shooting. However, she reached a plea deal with the prosecutors in which she agreed to plead guilty to 1 count of second-degree murder and 1 count of armed criminal action. The judge sentenced her to 25 years for the murder and 10 years for the lesser charge to be served consecutively, which means one after the other. So once she's done with that 25-year sentence, she'll start the 10-year sentence. According to the arrest affidavit, this incident took place on December 31st of 2022, and Miss Ruckert was reportedly motivated to kill Mr. Miller after she went through his phone and found that he had been exchanging text messages with another woman. After allegedly making the discovery, police said that Ruckert waited for Miller to fall asleep before grabbing a firearm and then shooting him. Following the shooting, Ruckert drove a short distance north to Dallas County, Missouri, where she reportedly spent the night hiding in the woods. The following day, Ruckert drove to the Dallas County Sheriff's Office and turned herself in to the police. Detectives traveled to the Dallas County to speak with Ms. Ruckert, who reportedly provided details about her motives and the murder. A handgun was recovered from her car, and it matched the weapon used in the shooting. Now, Miller's mother, Ann Kopp, spoke the day after she learned of her son's death and said that she was baffled by what police had told her because she just couldn't believe that he'd been killed because she found messages from him from another woman, and he had never, ever cheated, according to his mother. You can't trust a guy's mother who said he's never cheated on her. I don't know what you can do, but don't you think there's another way of going about it, ladies and gentlemen? You know, you find text messages, leave, move out. Shooting somebody in the sleep, probably a little over the top, hence the reason why she's going to spend the next 30 years in prison. Next, this day in legal history. On this date, April 29th, 1862, the Homestead Act's debate advances, later shaping land ownership laws, but sparking legal dispute with Native Americans. April 29th, 1913, the 17th Amendment is ratified, mandating direct elections of senators, reforming electoral law to curb corruption. How'd that turn out? On this day in 1961, the Federal Wires Act's debate advances, later prohibiting interstate gambling, shaping modern online betting laws. And then on April 29th, 1992, 6 days of rioting broke out after the Los Angeles police officers who beat Rodney King while being filmed were acquitted by a jury. The verdict ignited a powder keg of discontent about police discrimination against LA's black community. The riots would result in more than 60 deaths and $1 billion in property damage. On this date, April 29th, 1996, the Anti-Terrorism and Effective Death Penalty Act's effects strengthen, limiting habeas corpus post the Oklahoma City bombing. And finally today, our dumb criminal of the day. Police said they were searching for a man who allegedly hid plastic Easter eggs across the city containing marijuana, then posted clues on how to find them on social media. Now, according to a press release from the Lufkin Police Department, officers received a tip about a Facebook account that was posting about plastic eggs full of marijuana hidden in various parks around the city for a scavenger hunt. The suspect posted 4 photos of on Facebook showing each location as hints to locate the eggs. He also posted a photo of 5 plastic eggs in the seat of the vehicle. Officers found 4 eggs and believed that he had not placed the 5th. Officers learned that they were incorrect in their assumption when a man and his granddaughter turned in the final egg into the department the next day, having also found it in the park. In total, police said they recovered over 1/4 of an ounce of marijuana. Investigators identified Avante Nicholson as the suspect behind the scavenger hunt by combing through his Facebook page. They also found statements referencing selling narcotics on multiple occasions and in other posts. He states whoever shopped with him on the day of the scavenger hunt would get hints to the location of the eggs. Police have not been able to locate Mr. Nicholson before they published their releases to their findings. Sir, you are our dumb criminal of the day. Mr. Nicholson, Mr. Avante Nicholson, putting eggs out where a minor could get them, not good. And technically, that's distribution. And what's even worse is if you did it near a school ground or some sort of protected area, that could be an aggravated sentencing enhancer. Mr. Nicholson, you are our dumb criminal of the day. Congratulations, you made it. That's all we have for you today, ladies and gentlemen. Thanks for watching. We'll see you next time on Crime Talk. And remember, the Constitution matters.